Michael Popak, by the looks of things, it's legal AF after dark. Want to know about the New York criminal trial from the perspective of a prosecutor who was in the Manhattan DA's office for 30 years and a defense lawyer who practices in New York? You've come to the right place. Legal AF, the podcast you can only find on the Midas Touch Network. Take a listen to our most recent episode, the New York trial. I'll give my 2 cents and turn it over to you. We got a contempt hearing that led off a part of this week, in which, as I only slightly jested at the opening, it was Todd Blanche who's increasingly losing his credibility with this judge against Judge Merchant. Very little of what Todd Blanche said in the motion for contempt hearing to try to stop his client Trump from being found in contempt for violating the gag order was resonating with the judge. In fact, he was the, and I think this applies to Trump too. They're just the incredible shrinking men. They're just shrinking before our very eyes. Trump is just, if you took him to a copy machine and you put 65% reduction, that's what you're seeing of Donald Trump. He's not the president in that courtroom. He's not even the leading candidate for the presidency, as he likes to say. He's just a guy in a suit. That's a garden variety criminal defendant. And he's given just that amount of respect, or no respect, as anybody else. When he tries to leave the room early, the judge says, "Sit down, sir. You're not excused, just like anybody else." And so what I've said in prior hot takes, I'm going to get your view as a former prosecutor. Trump and his lawyers are losing credibility almost moment by moment in front of this jury, both in the things that they were told in their opening statement by Todd Blanche, and then the way Donald Trump just acts in the courtroom, which is diminishing him and making the jury sort of get annoyed. On the contempt hearing, I'll take a break for a minute. We'll stay on contempt. You heard the evidence. You know how many times he violated that gag order. You know the issue about reposting of other people's negative comments about witnesses and jurors. 2 questions for you, Karen. Did he violate the gag order? And what does the judge do about it within his toolbox of things he can do? $1,000 fine and/or jail, either in the back of the courthouse or at Rikers Island. Let's just stay on contempt. What do you think about that? Yeah, so look, he's violated it at least 10, 11 times. And in fact, he continued to violate it last night. He was talking again about witnesses in the case and going to places that he's not allowed to go given the gag order. So he's just showing no interest in stopping talking about it. And despite his coming out and saying he's under a gag order and can't talk about the case, he talks about the case. He talks about Alvin Bragg, which he's allowed to do. He talks about the judge, which he's allowed to do. And he gets to talk about himself. He's just not allowed to talk about witnesses, people's families, and jurors. Yet he does that anyway. And at the hearing, what was so frustrating was the fact that they were not even providing any legitimate or straight-faced reason or excuse for it. And the judge wasn't having it. And at first I thought, wow, Todd Blanche must be so upset because the judge said to him, "You're losing all credibility," when he made arguments like that. Donald Trump is trying his hardest to comply with the order. Or, "Hey, judge, we thought it was waived because the prosecution only brought a few of the content." Only brought it first, if you recall. They only brought 3 of the postings saying he was in contempt. They didn't bring the other 8. And so we thought it was waived, which both arguments have absolutely no merit and completely strain any sense of a credible argument. And at first I thought, this is so surprising. Todd Blanche is a much better lawyer than that. And the judge kept saying, wait a minute, the other argument he was making was Donald Trump's just responding to criticism and attacks that the witnesses are making against him. And the judge kept saying, show me, tell me what post specifically was he responding to when he did this. And he went post by post, and of course he couldn't answer anything. And at first, like I was about to say, I thought that's so weird. Todd Blanche has a reputation of being a really excellent lawyer. And on the very first day of trial, essentially the judge is saying to him, or the second day saying, you are starting to lose credibility with the court, and interrupting him, and really asking him pointed questions in sort of a Socratic method. I thought it was a disaster. I mean, this is an absolute abject disaster for him. But I've come around. I don't think he's a bad lawyer. I think he's an excellent lawyer. He didn't have anything to work with. He didn't have anything to say. He was doing his best to try to make legal arguments with shit facts, because Donald Trump is not trying his best. He is not making any effort. He can't point to anything that it's a response to. And so look, he's still a lawyer who has to advocate on behalf of his client. He still has to do the best he can, making arguments as horrific and bad as they were. I do think he probably shouldn't have said anything to lose credibility with the court. Like I said, that's a terrible, terrible... Can I give you an example? I agree, he's got a reputation for being a good lawyer. I haven't seen it yet. Even his opening, I thought. We'll talk about it next. His opening, he's writing lots of checks he can't cash in front of this jury. And your prosecutors, your former colleagues, are going to make him pay dearly for having done that and misled the jury for having done that. But like when in the contempt hearing, when the judge, first of all, I learned in moot court in law school that when the judge's mouth is open, your mouth is closed, even if you're at mid-sentence. So I didn't appreciate that he has taken on the persona a bit of his bully client. And when Judge Merchant said, I need to get to the bottom of the timing of your client's social media posts in order to make my ruling. Why does the timing matter? Blanche interrupts. And the judge says, I ask the questions here, not you. You know, I've never been told. I've been doing this a long time. And I've been on my feet a lot with shit facts and not a lot to argue. But I still find a way to preserve my credibility so I can advocate another day in front of that courthouse, in courtroom, in my own professional livelihood, and not to interrupt the judge and get belligerent with them. It's almost like he's doing show performance again, theatrics for his client, to make his client pay his bill.
Yeah, look.
I'll tell you this. So think about Judge Merchant. He welcomes vigorous advocacy. He welcomes it. So he wants people to advocate strongly on behalf of their client. And Judge Merchant is a measured person. So for him to say, you are losing credibility with the court, that's about as close to Judge Merchant comes to losing his temper, I have to say. Like it might be kind of, it was slightly intemperate for his rep, That just goes to show how much he thinks that this was a terrible argument. And that just should show you what hot water Donald Trump is in. So what do you think? Fine. Prison? Jail? I think a couple of things. It was reported that the people who manage corrections are making arrangements with Secret Service about what it would look like to put Donald Trump in jail, certainly considering it as an option. And it's an option, not necessarily for this particular set of contempts, but I could see it as an option in the future if Donald Trump doesn't stop, and he shows no sign of stopping. Like I said, he even continued last night with his, and yesterday with his postings. I think last night he was speaking to the Detroit. I think it was the Detroit, a show in Detroit that he was commenting on. And he continued to violate the gag order there. So I think Judge Merchant is preparing for that option in case it comes to that. You don't want to do that. And then all of a sudden corrections says, oh, well, we have no idea how to handle this. So there is a logistical thing because he is under 24/7 surveillance and protection, not surveillance, protection by the Secret Service. And so how would that work in terms of guards guarding him if he's incarcerated? So I do think they are doing that, and I think they leaked it on purpose, by the way, so that the lawyers and Trump and everybody knows that this is a possibility and it's a serious consideration down the road. I don't think that's what he's going to do at first blush. The thing is, so I did some research and I actually co-wrote an article with Norm Eisen and some other folks in just security. And I was on the law of contempt because when this started coming up, I thought I haven't looked at that law in a long time. And I started researching it and just brushing up on it again. And the law of contempt in New York is really complicated. There's 3 different contempt laws. There's a criminal one, a civil one, and a judicial one. And so it just depends. Each one has different sanctions, different options available. The one that is coming this way, the one that the order to show cause that the DA's office brought, that one allows fines of $1,000 per violation. It can go up to 5,000 if it's persistent, or 30 days in jail. So I think what he's going to do is he's going to sanction him $1,000 per violation. Maybe not for all 11. Maybe there might be one or two in there that he says are ambiguous or decides not to bring. But by and large, I think he's going to get hit with a fine for almost all of them. I do think he might also get a very stern warning that if you do it again, this is your last fine. If you do it again, that's when we're going to start doing other things. The reason he was asking the timing of some of these posts is because the judicial contempt or summary contempt, if that happens in court, that gives the judge the ability to you don't have to bring a criminal complaint. You don't have to hold a hearing. He can just handle it himself because there is this ability for judges to be able to maintain order in the court. And so if he is tweeting or posting or speaking outside in the hall, criticizing witnesses or jurors, that give the court power and authority that's a little more swift and quicker than the other types of contempt. You might start seeing things like that Judge Marchand puts Donald Trump, puts him in, when I say put him in, I mean puts him in jail, puts him in for an hour, puts him in for 2 hours, makes him sit in the courtroom in custody over lunch, he's in custody during the court day and he's not allowed to go outside and make those speeches. He might do it like that. And there is a holding cell in the back behind the court where prisoners who are incarcerated when they are coming to court, they hold them there and keep them there. That could be the jail cell. And of course, if he doesn't continue, they can escalate it further. But I think he's going to start doing more and more things. He could also revoke or change or amend his bail release conditions as well. So that gives him other options, and he can just do what he has to do to keep this under control. The third rail that Donald Trump keeps hitting is the jurors. When he says things like, this is a biased jury, it's 95% Democratic, there's going to be someone sneaking on the jury to get me, that kind of thing. That is incredibly threatening to jurors who might hear about that and could make them feel pressure that, wow, if I don't acquit Donald Trump, bad things are going to happen to me because I know what happens when you get in. I saw what happened to Ruby Freeman and Shay Moss and their life that was upended. I saw January 6th, etc. His followers can be really scary. And so that's why the judge is going to really come down hard on him when he says anything about the jury whatsoever, and same as the witnesses. So it's really interesting to watch this happen, but I think we're going to see him respond strong and swift. Great, and I think we're going to get that, I agree, early. Let's do a quick overview of the opening statements and the theories and themes of the cases for both the prosecution presented by Matt Colangelo and Todd Blanche. They were much shorter than I thought they would be, at least from the defense standpoint. I'll do Blanche and you do Colangelo. How's that sound? Got it. All right, and I think the way our timing is going is I'll do my little overview of Colangelo, of Blanche's, what he did, and then we'll take our first break for commercial, come back and hit up Colangelo with you, Karen. So, this is what's called a little bit of a teachable moment here. Opening statement is not supposed to be argumentative, but all trial lawyers try to get as close to that edge as possible. You're supposed to be talking about what you believe the evidence will show. What you're not supposed to do is vouch for your client. Tell the jury, I'm just like you and me. I'm also a Manhattan resident, and this guy's not guilty. The problem with what I just said is all those golden rules were basically violated by Todd Blanche, which is why one of the reasons the Manhattan DA was jumping up and down during opening statement, and many of their objections were sustained. Because Todd Blanche, as you said earlier, and I'm going to repeat it because I liked it, he didn't have shit to work with. And so even in his opening, he was left with trying to vouch for your client. You can't do that. You have to be an advocate for your client. You can't say, you know me, you like me. Jury, I go to coffee shops in Manhattan just like you do. This guy over here, he didn't do it. He's innocent. I mean, frankly, it violated every cardinal rule and even potential error that I've ever been taught in successful trial practice. And I didn't find it surprising because I don't think, as you said, to paraphrase my colleague, I don't think he had much to work with. Rather than take on, he knew. You and I, Karen, could have written the opening for Michelangelo. We knew it was going to be some version of the Trump Tower conspiracy. I've been doing hot takes on this for over a year. I could have done that opening. So could you or Ben? We knew it was going to be, there was a meeting with 3 people. I know Cohen, Pecker, Trump. And from there, the catch and kill program was devised. I mean, I could have written the opening. So you know what he's going to say and what you need to do in what you get the chance to speak second. And you've already heard the guy go first. You've heard Matt Michelangelo go first. So you knew he was going to focus a lot on that and that they were going to anticipate. You'll talk about Michelangelo, Cohen. And instead of taking on Pecker, which they knew by this point was going to be the first witness, he really just took on Cohen. And what the total takeaway in 20 minutes of an opening statement, by the way, I don't think I've ever done 20 minutes. I can't clear my throat in 10 minutes. 20 minutes. I mean, I've got cases just about money, and it takes me an hour to walk through the evidence and what the evidence will show and witnesses, let alone this. And this is your chance, your first chance to build credibility, authenticity with the jury, to make them like you, to make them want to follow you, to demonstrate to the jury that you're not going to mislead them. Well, he misled them in a number of ways. First of all, as you said it was either one of these programs you're doing with Ben or it was with me midweek, I forget which one. But you said a version of, I think he flipped the script on the burden. The burden's on the prosecutor. Why is he talking about, we'll prove his innocence? You don't have to prove his innocence. You just have to prove that there's reasonable doubt. They have the burden, not you. So that was weird. It was also weird for him to bolster the client and say, this guy, he's innocent, and I'm going to prove it to you. And then when he went off to try to prove it to them, he totally misstate what he knows to be the evidence. Like he said, for instance, you're going to hear a lot about the National Enquirer. And then he started to do this mock. Again, this is like when they say dogs, pets, start looking like their owners. Blanche started taking on characteristics of Trump. Hoppe does. And he started mocking with a mocking tone, which you and I know juries hate, unless they're in on the joke, which they rarely are. They laugh at things you didn't even expect them to laugh at, and they will not laugh with you at the things you think are funny. I'll just warn, this is my trial practice breakout moment. So he starts mocking the Trump Tower conspiracy. The Trump Tower conspiracy. Yeah, it's the Trump Tower conspiracy. That's when 3 people to get together and make a tacit agreement to do something illegal. That's what we call it. I don't know why that was so funny. And the jury was like taking notes throughout all the openings. I didn't think that was that funny either. And then he started to mock, Michael Cohen, which, I guess fair game there on that one. But then he started talking about things that he can't deliver on. The National Enquirer is just a legitimate media outlet, and they make their own editorial decisions about what stories to run. Come on, Todd. The first witness, first thing out of his mouth, they didn't even do tell the jury about yourself. What's your title? What do you do? They started it within the first 20 minutes, and they got out of David Pecker that we practice at the National Enquirer, checkbook journalism. Everybody laughed in the courtroom. What is that, sir? Oh, we just pay for stories, and we put them in there. And then before the first day was over, Pecker said that we didn't want to run these stories. Michael Cohen, on behalf of the campaign, called and told us to run these stories against political adversaries of Donald Trump. So we ran them, and it didn't really help us with our sales. So we really did it just to help Donald Trump and his campaign, which, by the way, is the second crime necessary for a felony. He knew, Blanche, that they were going to say all of this. They should have known all of this. And yet he lies to the jury, and the jury is going to punish him. And the prosecutors are going to punish him at the end of the trial. When they make that, they say, those things that Mr. Blanche told you? They'll read from the transcript. Remember when they told you this? None of that was true. Here's the testimony that you really heard. They're going to go, right? We were had by Blanche from the very, very beginning. I talk about it like if you're going to write a check, you got to be able to cash it. If you don't, your opponent is going to nail you. And I'll leave my comment on jury on one point before we go to our first sponsor. Jury science tells us, and I'm sort of a student of it, I'm sure you are too, Karen. Jury science tells us that it doesn't matter how long the trial is, the length of the trial. Juries make their decisions very, very quickly about who's winning and who's losing, who's going to be convicted and who's going to be exonerated. After the opening statements, maybe the first witness, which has gone exceedingly well for the Manhattan DA, they're about ready to make their decision. Sure, they'll listen dutifully for the next 6 weeks of trial evidence, documents, copies of checks. But if you were able to do this trick, I'm going to propose this mind experiment. If you were able to pull the jury, like after Pecker is done, and then get their jury verdict, it'll match up pretty closely. And if I'm right about that, and jury science says I am, and my own experience says I am, Donald Trump's cooked in that courtroom. But I want to hear from the prosecutor on this team, former prosecutor, Karen Freeman Nipolo. Yeah, so look, the opening statements, the people are required to give an opening statement, the defense is not, and the law requires the people to do that. And so that was something he had to do. I was surprised he did it. He's not known to me as a trial lawyer, but that doesn't mean he's not. I just never worked with him before. But they gave him that really important role because it's all about connecting with the jury. As you said, it's so important in the beginning to really get to know them and connect with them. And he didn't do any of the Ward years, so maybe they were trying to introduce different team members to the jury, but so far they don't really have one person necessarily that seems to be rising to the top as the leader of the trial team. Josh Steinglass is the one who's doing David Pecker and doing that direct examination, and he's the senior trial counsel on the team. And so Susan Hoffinger, allowing Matt Colangelo, who in his own right has a great reputation and comes from the Attorney General's office in the Department of Justice. He's apparently a great lawyer. They had him do the opening, but his opening was good. It was just very much what it needed to be. He got the nuts and bolts out, which the law requires you to do. You're supposed to give a preview of what you think the evidence will show. You're not allowed to argue. You're not allowed to spin, even though you can subtly do it by word choices, etc. But it's really just meant to be a preview of what you expect the evidence to show. And I give it a B, I would say, or a B+. I think it was really good. I didn't love the way he handled the Michael Cohen piece of it. I think that Michael Cohen is going to have some impact on the jury, both positive and some negative that you want to take the sting out of. And he kind of characterized Michael Cohen's issues as he has some prior past mistakes, which I guess that's one way of putting it. I think it slightly undersells it a little bit. And so that was that. And it's clear that Michael Cohen's going to factor huge in the defense case because the defense attorney, Todd Blanche, spent a lot of time in his opening talking about it. So I just thought that he could have done a little bit of a better job really putting Michael Cohen's life in context and his flaws, really kind of put them out there and put his spin on them. So that was the one thing I kind of wasn't 100% in line with how they handled it. But I do think, frankly, the opening is something you have to do. You get through it. So much of the stress, though, of an opening statement is you don't exactly know how the evidence is going to come in. You think you know, you hope, but there's a lot in this case that is unknown, right? You've got people who are co-conspirators who are testifying, and you don't know what's going to happen when they take the stand, and they're sitting in the same room as Donald Trump, whether they're going to deliver the same as they do when they're in your office. And so the opening in a criminal case as a prosecutor, you don't want to overpromise. You don't want to necessarily commit to certain things that you don't know you can deliver. Because I think that that's really where the jury's unforgiving, because the prosecutor has to prove it beyond a reasonable doubt. The defendants just has to create some doubt. So if they fire a bunch and then miss a few, that doesn't necessarily equal beyond reasonable doubt, right? That just means they're doing their job, And juries expect defense attorneys to also argue a lot more and promise a lot more. But the prosecutor you can't make any mistakes. One small mistake, and that's your doubt right there. And you can't have all the theatrics that defense attorneys can do. You have to be the one they can trust and the one that really plays it down the middle. And so I think he did a really good job at doing that, at really just sort of talking about the things that he knows the evidence will show, but also not overpromising. And the thing of the trial, though, that has really blown me away is how incredibly crucial and critical and just overwhelmingly devastating to Donald Trump David Pecker has been. He's not someone that the media or even we focus on very much, right? When people talk about this case, but Cohen and Stormy Daniels is definitely always talked about the most. Pecker they were smart to call him first. This guy, and he's certainly not the subject of Donald Trump's ire either. Donald Trump doesn't go after him the way he goes after the other witnesses publicly. So I guess that's why he just wasn't top. He wasn't some people were like, why is he the first witness? And I think I too had a little bit of that at first. I don't know, I had a debate about it. I admit, he said, I think they're going to start with a checks person. I said, there's no way they're going to start with a checks person. I said, you got to start with as close to a roadmap witness as you possibly can. I knew it wasn't Cohen. And I said, I gave a list. I said Pecker was in the top 2 of my list because I knew Pecker was going to be able to tie, especially when you lead in your opening with the Trump Tower conspiracy. There's only 3 people to that conspiracy. 2 are going to testify. But more importantly, to your point, Karen, I'll turn it back to you, is that Pecker does something that we're going to see over and over again. Talk about the smartness of the trial strategy by your old office, is they know they've got a Michael. They've got a problem named Michael Cohen in terms of him having great facts that need to get out be induced as evidence, but it comes wrapped in a package. It's a little bit compromised. Something that Michelangelo alluded to. And of course, Donald Trump was always going to do that. But in order to put him in the best possible position to perform properly, and Stormy Daniels too, you put witnesses that are unassailable, like David Pecker first, to bolster the future testimony, even though that's not technically correct. Bolster the future credibility and testimony of witnesses later on. Michael Cohen's going to be sandwiched in the middle of a bunch of stuff. He's not coming up next. It'll be another few people to get a momentum going by this prosecution team, along with Pecker. Pecker's not even dumping on Trump. And to your point, surprisingly, Donald Trump went after Cohen, and went after Cohen in the opening, went after Cohen in social media, but he's silent. It's almost like he's endorsing Pecker. And that's terrible for him, because as you said, he hasn't done a darn thing to tear down Pecker. And Pecker, which is what I love, and you worked with Josh Steinglass, you can give your comments on this. He's got a conversational style going with Pecker right now, which is just 2 guys over a cup of coffee and a bagel and a schmear having a conversation, and they're laughing and they're joking, and Pecker's very relaxed. You can tell it's been rehearsed. But that's great. I mean, when you're an examiner, you've done this. Oh my God, you love, but you're just having a chat, and the person's not, yes, no. I don't know what you mean. You'll have to show me a document. You don't want that. Pecker is dumping willingly on Donald Trump and supporting the entire case before we even hear. They can prove this case without Michael Cohen, by the way. There's very little that Michael Cohen would need to testify to that isn't in text messages that are going to be put in. Emails, secret recordings Michael Cohen made, that by the time Michael Cohen, it's going to be like, for me, it's going to be like an afterthought after all this mountain of evidence comes into the courtroom. What did you think? Well, I wouldn't understate the importance of Michael Cohen. All the things you allude to can't come in without Michael Cohen. He has to authenticate them and put them into evidence. So I don't think they can try the case without him, but at the same time, I do agree with you. It's going to be corroborated by all this other evidence. But what Pecker was able to do was he really provided the roadmap for the criminal scheme. He talked about when they devised this criminal conspiracy, right, at that meeting at Trump Tower with Pecker and Michael Cohen and Donald Trump, where they were going, and they agreed that they are going to play catch and kill. They are going to amplify negative stories about Donald Trump's opponents, like Ted Cruz, and make up these crazy stories, or Ben Carson, that he left a sponge in somebody's brain during surgery, or that Ted Cruz's father had something to do with the assassination of JFK. I mean, it's just crazy, crazy headlines that they're going to amplify those things, amplify positive stories about Donald Trump, and then they're going to play catch and kill. And I think that's just so preposterous. I mean, it's just so preposterous. And that they're going to suppress negative stories about Donald Trump, and they're going to engage in a catch and kill. Now, catch and kill is a thing that happens, and it is not illegal per se. But when you become a candidate and you're purpose for, and you're going to pay people off, but the candidate, in order to get them to be elected, that's a crime. And I actually had an on-air debate with Tim Parlatore. I think it was Tim Parlatore, or maybe it was Tim Parlatore. It was either him or Jim Trusty. I can't remember. I was on with both of them. It might have been two former lawyers for Donald Trump. Yeah, I was sitting next to them, and I was on the air with both of them last night, having a debate over this, because they were saying, one of them, and I can't remember which one was, and I apologize that I can't remember which one. The younger guy is Tim Parlatore. I know which is which. The blonde is Tim Parlatore. Yeah, the older guy. Yeah, I know which one is which. I was on for so many hours yesterday that I just can't recall. But I'm pretty sure it was Tim, and Tim was saying that Citizens United, the United States Supreme Court case that talked about a documentary that was made to help in Hillary Clinton, that they said that's First Amendment speech, and that doesn't count as an in-kind campaign donation, to which I said, spoken like a true defense attorney, whereas I'm the prosecutor, would say, yeah, well, when you specifically go out and pay people off, and that is an in-kind campaign donation. So I got him to at least admit that the case that Citizens United hasn't been tested to that point yet. But we kind of had a debate about whether it would be illegal or not, or criminal scheme. But that's what's going on here. And the prosecution's theory is that's an illegal scheme because it was a campaign contribution that nobody was going to claim. And they were going to cover it up by doing things like cooking the books like they did in this case. Well, those are the two crimes, right? You got the misdemeanor, which is the business record fraud. They listed the payment to Stormy Daniels as a repayment of legal services to Michael Cohen. Let me make this clear to the audience. You want to pay off Stormy Daniels and make her not go public with your story? You can do that, and do it in a way that doesn't commit a crime, nor with a multi-stepped, multi-headed conspiracy. Problem is, that's not how Donald Trump did it. And the second thing is on the crime. Back to Karen for a minute, how did Tim or Trustee explain then why Michael Cohen went to jail for almost 2 years for paying off Stormy Daniels? How did he get convicted of a federal election crime and Donald Trump wouldn't have been convicted? Yeah, well, we didn't have that. We didn't continue down that road. Can I phone a friend? But yeah, no. But it was an interesting discussion, right? It was a very interesting, spirited discussion with Jake Tapper yesterday. But that's where we were, that's what we were talking about, but that's what this boils down to. This boils down to a criminal conspiracy that one of the co-conspirators, David Pecker, was the one who actually spelled it all out in detail about how it was going to work, what they were going to do. And he really talked about how the sausage is made at the National Enquirer. I mean, and it was really, the thing that was also really interesting that he said was that, and I think this really helped the prosecution. There were two things that I thought were really helpful to the prosecution, in addition to the things everyone else is reporting on. Number one, he said that the story, The Doorman, remember there were 3 people catching kills. There's the doorman who said that there was a child out of wedlock. There was Karen McDougal, who he had a 1-year affair with, and Stormy Daniels, who he had had sex with once. That the doorman in particular, that story had been debunked. And what Pecker said was, if that story hadn't been debunked, we would have run that story after the election. I thought that was critical to show this was for the purpose of the election, right? That is going to be a key piece of evidence that this wasn't about Melania. This wasn't about, right? This wasn't about Melania. Anyway, so Salty just checked. It was Jim Trusty who I had this debate with. Sorry, Tim. Anyway, so that, I can't believe I couldn't remember which one that's all right. And for those that are following at home, cast the characters. Jim Trusty was one of the lawyers that had been the lawyer before Donald Trump fired him in the D.C. election interference case. A former colleague of Jack Smith when they were two different division heads at one of their offices. And Parlatore, it's hard to believe he's been around so long, was a Mar-a-Lago lawyer who decided to leave when he thought Boris Epstein, who I can't believe hasn't been indicted, is a lawyer for Donald Trump, was meddling too much in the decision-making around strategy. And now they get paid, whatever they get paid, to show up on CNN and talk about their former client. Anyhow, so I thought that was pretty significant that he talked about how this was absolutely election-related as opposed to Melania-related, which I do think is significant because that's the difference, right? Between crime and no crime, frankly. That's number one that he said that I thought was really, really critical. The other thing is there was a question that Josh Steinglass asked him about headlines, and about headlines that Pecker was talking to Michael Cohen about these headlines that he was getting out. And he asked Michael Cohen whether he had conversations with Donald Trump about it. And when Steinglass asked him, because he dealt with Michael Cohen a lot more than he dealt with Donald Trump, he said, I don't remember him ever saying that the boss approved or the boss was involved in this one particular thing. And that's going to be a summation point for the prosecutor, because he's going to say when he sums up, or she sums up, depending on who does it, they're going to say, if David Pecker were lying, he would have, and he was making this up, right? He would have said, he would have made it worse for Donald Trump. He would have made Donald Trump more involved. But he wasn't doing that. He was just telling you the truth. He was telling you the things that he was involved in, the things that he wasn't involved in, and he was telling you the facts just as they are. And to the extent that they match up with Michael Cohen and the other witnesses, I do think that's going to be critical for the prosecution. He was just an absolutely critical witness. He's still on. We still haven't gotten to cross-examination, but I think it's interesting that Donald Trump has not publicly gone after David Pecker, which in some ways is like endorsing him. And the other person he hasn't gone after is Karen McDougal, the way he goes after Stormy Daniels. And that's really interesting to me because there is an argument that the affair happened during the time that Melania and he were together, and she was pregnant with Barron. And from a I want to protect my wife standpoint, having a long-term relationship with somebody that clearly had feelings involved and was much more than a one-night stand, I don't know if you're going to protect your wife from one of them. I would think it would be the former, but he doesn't seem to be denying that publicly. The other thing that I thought was weird was David Pecker was saying that Donald Trump was considered the most eligible bachelor. And I was like, he's not a bachelor. He's married. The time he was talking about he was married. Yeah, exactly. The 80s and 90s, he was an eligible bachelor. Well, anyway, but not at that moment. Yeah, anyway. Well, there's an example of what we do twice a week on the Midas Touch Network. We call it Legal AF for a reason. And now you know why. We curate the best stories at the intersection of law and politics. We bring it to you. No BS, no filler, no smoke, no sunshine. Just pure, unadulterated, proper legal and political analysis that you've come to expect from Legal AF. We do the show on Wednesdays with me and Karen Friedman at NIFLO, Saturdays with me and Ben Mazelis, and then on Hot Takes, about every hour on the Midas Touch Network. So if you like what we're doing here, you're already part of our audience. We really appreciate you, seriously, from the bottom of our heart. We couldn't do it without you. Take that clip, be part of our marketing department, send it off to friends and family, and say, hey, Legal AF, you know that show, I like it. Here's an example of it. Maybe they'll join our audience. If you don't know what I'm talking about, that was Legal AF. I'm Michael Popak, and I invite you to join us every Wednesday and Saturdays on our YouTube channel for Midas Touch, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Here, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.